Good afternoon. I'm Christine Petrozewski with the Chamber of Olean, and I'd like to introduce Kristin Devereaux. She is the president and owner of Envision Benefits Group, here to lead our virtual lunch and learn today. She'll be speaking on HR and labor laws. So, Kristin, go right ahead.
All right. Thank you, Christine. As Christine says, I am Kristin Devereaux. I'm with Envision Benefits Group, and this is one of my favorite things to do, talk about compliance and labor law. And our firm specializes in human resource consulting, employee benefits, and payroll services. So for those of you that are not into this topic, I apologize. It is an unnecessary evil for us to keep up to date with these compliance changes. I always like to tell our clients, if you haven't done at least 5 to 8 handbook updates in 1 year, then your handbook is more than likely out of date. So it's important that to note that some of what I'm going to go over is already in play. So it may have happened already sometime earlier in 2024, and then some of what I'm going to go over is what's going to be happening in 2025. So I've been told I have about 40 minutes because after that I lose people's attention. So what I'm going to say is, if you have questions, there is a Q&A panel where I will be able to see what you type into that panel. And as I go along, I can try to answer those questions. If we don't have time, what I'll do is I'll try to answer questions for those of you that want to stay on after the presentation and answer the questions live, or the Olean Chamber will export the questions that have been typed into this chat box, and I will answer them through email for you. So all of that will be sent out along with a copy of our slide deck and the recording of the presentation after the presentation. So a couple things that we're going to talk about today. The Federal Labor Standards Act minimum salary thresholds. There's been some changes at the federal and, of course, at the New York State level. And there's always a lot of confusion surrounding salary and hourly employee classifications. So we're going to talk a little bit about that too. We're going to talk about the Pregnancy Workers Fairness Act, the EEOC harassment updates and definitions. We're going to talk about the New York State paid prenatal leave, the paid breast milk expression, the continuation of COVID paid leave that has not gone away yet. It will be. And then we're going to be talking about Retail Worker Safety Act and, of course, the sexual harassment training. So the first thing I want to talk about here is the federal salary threshold. For those of you that are familiar with this, the federal government and the states have the right to set certain levels for minimum salary in order to classify an employee as salaried, which means that they don't get overtime if they work over 40 hours a week. So in 2024, the beginning of 2024, it was set at $35,568 annually. So that's about $684 weekly. It's a very low wage, but that is at the federal level. In July 1st, they did change that to $43,888 annually. So we had a lot of clients have to go through. Some of the clients that aren't in New York went through to make sure that they either raised the salary for those people that were in that bucket at the $35,568, or reclassified those employees as hourly if appropriate. So then in January, we are going to take another increase at the federal level to $58,656 annually. So in 1 year, we're going from $35,000 to $58,000 at the federal level. Now, this is for exemptions for salary employees that are administrative, executive, and professional. There are other exemptions that we have both in New York State and at the federal level. These are the most common, and these are the most straightforward that I'm going to go through with you. The other ones, some of them have some significant nuances to them, and I may touch on them a little bit as we continue to go forward. But after January 2025, this federal salary threshold will continue to increase, just like the New York State one does. I'm assuming that everybody here is a New York State business, which means we are subject as business owners to the New York State salary, the minimum salary threshold, and we've always been above the federal level. So if you have salaried employees that are not meeting the numbers that you see here for 2024, it's 58,500. If that is not their minimum salary, so if they're making less than that and you've classified them as salary, that is not that's not meeting the threshold. So you are in violation of that. So you definitely want to take a look at that. For New York State in January, we are going up to 60,405. So again, we're going to have to readjust those salary numbers at the end of the year to make sure that people that you have classified as salary are meeting that minimum level. If they're exceeding it, that's great. If they're not exceeding it or not meeting it, then you do have a problem. Okay. So this kind of is a little bit of an overview, a little bit more visual. I'm a visual person, so I like to see things laid out this way. But one thing I want to mention is New York City, or the state calls it downstate, has a certain threshold, and their threshold is higher. You'll notice here on the screen they're at 64,350, and then we are at 6405 for 2025. So just keep in mind, we are considered upstate, okay? The minimum thresholds for the federal are over here on the left-hand side. So you'll see 58,656 is lower than what our New York State minimum is going to be. So typically when we have the same provisions at the federal level and the state level, we as business owners have to go with the one that is richer, which is New York State salary threshold. So we have to abide by that. Now, I didn't mention the highly compensated, which is on here too. New York State does not have a level of highly compensated employees, so they don't have a specific salary for that. So that does have to meet the federal guidelines, which is the 151, 164. So if you've got a highly compensated employee making less than that, then that exemption, that particular exemption, does not apply. And there are three basis to determining, or three tests determining whether an employee is actually hourly or whether they can be classified as salary. Okay. So to determine if someone is actually going to meet the definition of a salaried employee, we have to make sure that their salary is not fluctuating. It's not going to change, right? It's not going to change if they don't make a certain piece count. It's not going to change if they don't make a certain number of sales calls or what have you. It's just a flat dollar amount, and at least at the minimum of what New York State requires. So that's the first test. Is it a static, predetermined, fixed salary? The second one is the salary threshold. So are they meeting the minimum or exceeding, but are they at least meeting the minimum that's required in New York State? And then this one is the hardest one. This is the duties test. So I've got a lot of clients when I first go in that say, oh yeah, everybody here is salary. We don't pay overtime. And of course, we go through this process and find that the majority of their folks are really not salary. And we have to reclassify them as hourly because while they may meet the salary threshold, they don't meet the duties test, okay, or vice versa. So the employee's duties must be considered executive, administrative, or professional in nature, okay? So what exactly does that mean? There are actual documents and overviews that New York State puts out and the federal government puts out that have very specific guidelines on what these duties are based on the exemption that you're applying to that particular employee. So I like to give a few high-level ideas of what that means. So if I have a salaried employee, that employee is able to hire and fire employees without asking me, okay? So they have autonomy within the business, okay? They're making those decisions without consulting me, okay? Making decisions on behalf of the company without approval. So if there is a certain expense that needs to be paid, or there are certain decisions that need to be made that either that could technically cost the company money or not, they can make those without any approval, okay? So think of a CFO, right? they're paying invoices as they come in. They're shelling money out. They're reconciling books. They're doing things at that executive level, focused on the business, making decisions on behalf of the business without the business owner having to approve or manage every single decision that they make. Okay, so salary exempt means we are not paying 1.5 times their rate in overtime if that person works over 40 hours a week. Okay, so that is a salaried person. Now, I do have clients that want to call certain employees salary non-exempt. Okay, and that is possible to do. What that means is the salary is fixed. Okay, so it's, let's call it $75,000. And if that employee does work over the 40 hours a week, that employee is still paid overtime. Okay, so that fixed salary is there for them, but in the event they do work over 40, the business does have to compensate them at that 1.5 times rate. Okay. I don't see any questions in the chat box, and that is okay. But if you do have questions, please feel free to type them in there, and we'll try to answer as we go through. Okay. So some considerations as you think about, auditing and looking at your salaried folks and making sure that they're meeting those 3 definitions, and making sure you're either that you're raising those salaries to meet the 2025 threshold. You want to be prepared for these changes, okay? You want to audit and make sure you understand who's impacted, and make the decision, are they going to remain salary? Are they going to remain hourly? And then any recruiting materials that include salary ranges, which all of them should, right? Because New York State requires us, as we put out job ads, to include salary ranges on those job ads. So that's very important that you note that. Those recruiting materials will also need to be updated as well. And then, of course, everybody's favorite thing to do is anytime there is an adjustment in an hourly or salaried employee compensation, a new wage theft form has to be completed and has to be on file. So this is typically seen when new employees are coming into the organization. There's a picture of it here on the slide. This one is the LS-54. This is what's used for hourly employees. There is a different form for salaried employees. There's a different form for tipped employees. There's many different forms. So you want to make sure that you're filling this out completely. And in this case, since you are changing someone's compensation, right here at the bottom, you'll see notice given. It's not at hiring in this particular instance. It's before the change in pay. Okay, so you're making a change in pay, and they're getting this, you're signing off on it, they're signing off on it, okay? So we're going to transition into the Pregnant Workers Fairness Act. This is exactly what it sounds like. Basically, it is a federal program that came out in 2023. It was updated in 2024, and it's basically to protect pregnant women and make sure that they're given accommodations when asked for. Now, for those of you that know the word accommodation, you know that they can be a little bit tricky. And this particular regulation is exceptionally tricky with regards to that. The reason so is the related medical conditions, while you only see a few here on the screen, they are amazingly long and very broad. So you want to make sure that you are reading what those related medical conditions include, because it's not just for the pregnant woman. It is for anyone going through abortion, pregnancy, miscarriage. They could be lactating. They could have postpartum issues. They could have issues or time needed to go have fertility treatments and things like that. So there is a lot of related medical conditions that apply to this, okay? So things that you might hear from an accommodation standpoint that are pretty obvious, right? You're certainly not going to necessarily say no to these quickly, but it really does depend on your company. So I'm having trouble getting to work at my scheduled start time because of morning sickness. Okay. I need more bathroom breaks because of my pregnancy. Or I need time off from work to attend a medical appointment because of my pregnancy. So one of the things that the regulation says is that, if something is obvious, right? So I'm walking into your office, I'm obviously 9 months pregnant, and I come in saying, hey, I need more, or I need time off to go to a medical appointment. We're not going to give me a set of paperwork that's going to have me go verify that I'm pregnant. Okay, it's obvious. So the regulations state that if the accommodation is asked for and it is obvious, you really shouldn't be asking the employee to go and get the accommodation or other paperwork completed by their doctor. Okay, if it's not obvious, right? I may come in, maybe I'm a new hire, and I come in and say, you know what, I need time for lactation breaks. Okay. You don't know whether I've had a child recently or not. You can certainly ask for medical documentation in that situation. So examples of accommodations: modified or light duty. So if you have someone that has to lift something or can't really move around easily, you might want to give them modified or light duty. Schedule changes. So if I'm sick, actually, I have an employee who was getting sick from like 8 o'clock in the morning till 11. I said, okay, don't start work until 11. So accommodating those schedules if you can. Additional breaks to eat and drink, and modified standing or sitting schedules. So sometimes when they're sitting for long periods of time, it's good to be able to stand up. So allowing them those breaks, or even if you have the desks that can rise, or you have those computer systems that allow the employee to stand up and work, those are good things. And then always to support the well-being of the pregnant employee. So this particular regulation can have its own webinar in itself. I'm really at a very high level with this. So if there are questions, please make sure that you're typing them in there, or wait until the end and we can talk through things. So some things that we don't want to do is refuse an accommodation. Okay, just out of the gate. I'm pregnant and I need more water breaks. Nope, you can't have them. Once we start refusing accommodation and not partaking in that interactive process, it opens up the opportunity for complaints to happen. We don't want to delay an accommodation either. So if Kristin comes to me and says, you know what, I need to be standing more often than I am, and I say, okay, well, let me talk to your manager and get some approval, and then I kind of never talk to the manager and never get approval because I'm hoping that Kristin won't ask me that again. We can't delay the accommodation. We have to interactively have that dialogue with the employee and come up with a plan and a solution. We can't force an employee into acceptance either. So if, for instance, you have an employee that says, hey, I need a standing desk, right? Because I need to be standing at least 4 hours a day versus sitting for 4 hours a day. And you say, well, I'll let you take a 5-minute break every 2 hours. And that's my only accommodation. We can't force them to take that accommodation. You have to actually go through that process and kind of lay all of that out for them and allow them the opportunity to take any accommodation that you're able to give them within reason. We can't deny a job or promotion, and we certainly can't retaliate. So when we think about accommodations, one of the reasons that we can say no to an accommodation is if it would impact the organization financially or operationally, right? So if I have a receptionist who sits out at the front desk and greets clients, because that's my business, we have clients coming in and out, and that receptionist says to me, well, I need to work from home. That probably isn't going to be a good fit for an accommodation. So in that instance, we're going to have to maybe come up with a different compromise, right? Because a person greeting customers as they walk in the door can't do that from their home. So if it's going to cost the money or the business a significant amount of money to accommodate, that can be grounds for refusing a particular accommodation. So very tricky, very nuanced. There's a lot more that goes into this. So I'm going to kind of stop right here. We do have a question in the chat. It says, with a salaried employee under the threshold for the year, if they will receive a bonus that will put them over the threshold, will the bonus count towards the salary threshold? For example, the employee was hired at $60,000 for 2025. Knowing a bonus of $1,000 is paid later in the year, can we leave that salary at $60,000? So in New York State, for you said January 1st, the employee was hired for 2025. You're at 6405.80. Bonuses, no, do not. You can't count that as salary, right? Even if you're guaranteeing it. If that $1,000 is put into the 60,000 that you offered, then that's different. Then you're meeting that threshold, that minimum threshold. And then as long as the duties meet the test as well, that person can actually be salaried. But no, you can't count a bonus or a commission or something like that as meeting the threshold. The actual salary, that base salary, has to meet that number. Okay, we're going to keep going here. So the EOC finally updated their harassment definitions and gave some examples of things. Now, these types of updates, none of these updates are new, right? So everything that we're going to kind of touch on here, this has always been considered harassment. The thing is, New York State has very specific things, right? They spell out their policies. I think we all have an 8-page policy in our handbook that kind of goes through a lot of this. And at the federal level, there wasn't a lot of meat on the bone, so to speak. So there was some updates in regards to LGBTQ employees. A lot of what we're seeing right now from a harassment standpoint are comments about an employee's appearance, right? It doesn't meet the norm. So, if I'm a man and I come in with nail polish on my hands or on my fingers and I have earrings, that's not typically maybe what people are used to seeing a man doing. So repeated comments, repeated questions by the employer or employees is considered harassment. Repeated misuse of the employee preferred pronouns. So if I'm a female and I am identifying as him or his, and you can continually say she or her, it's considered a form of harassment, okay? And then outing a person's sexual orientation, that is a personal and private information. If they kind of communicate that to their coworkers, that's fine. But as a business owner, as an HR professional, that shouldn't be you outing that particular person or their sexual orientation. Religious expression, encouraging or discouraging comments or discussion about contraceptive use or non-use. It's inappropriate in the workplace. And of course, thoughts on abortion or thoughts on pregnancy, with everything that's going on in the news, these are topics of conversation that you will hear out on the floor in the offices and things like that. And that is where we're seeing a big spike in harassment complaints. And then some additional points, touching or commenting on hair. It could be considered race or gender harassment, making fun or teasing someone because of a disability, or complaining about favoritism because, Kristin gets, 8 breaks a day because she's pregnant and I don't get 8 breaks a day. So favoritism as it pertains to a disability or an accommodation. And then, of course, virtual harassment. So any sort of harassment on whatever level, so virtual, in person, outside of work, what have you, it's all considered harassment. So it's important that you take a look at your policies, make sure that all of these items are in there. and they're touched upon. In most cases, most of this is touched upon in the standard New York State harassment policy. There are a few things I would suggest adding in as it relates to some of the points on this particular slide. The next thing we want to talk about is the New York State paid lactation breaks. So this became effective as of July 1st of 2024. So this is for employees that are pumping, that are expressing breast milk throughout the day, and they are allowed to do this for up to 3 years following childbirth, okay? So you can give them up to a 30-minute paid break for expression of milk. Now, this can happen multiple times in a day. And in the past, these breaks could have been paid, or you had the option to have them unpaid, where employees would be clocking out, taking that break, and then clocking back in for work. In this case, New York State is saying that's not allowed. And as of July 1st, all of these breaks have to be paid breaks. So one piece of advice, a lot of times employers will say, well, I want that to happen on your lunch hour, right? And when we had the opportunity to say that that's unpaid, happening on the lunch hour was fine, because typically in an hourly situation, that lunch wasn't paid, right? Well, now, if they are doing this at lunch break, that lunch break can become compensable. So we could have to pay them for that during that time. So number 3, documentation can be asked for when it's not obvious that the employee is eligible. And I'm going to go back to the same example that I gave you a little while ago. You newly hire me. You don't know that I had a child last year, and that I am still needing to pump during the day. So I come to you and say, hey, I need to take some breaks. I need to have a break schedule created for me. And you can ask for documentation when something is not obvious, right? But if you've had an employee for a couple of years, you know that they have given birth, and they're asking for the lactation breaks, you're not going to ask for that documentation, okay? You're going to go ahead and accommodate those breaks as needed. Now, New York State has very specific requirements as to where employees need to, or what kind of place they can use as a place for these lactation breaks. So it has to be a room with a locking door. It cannot just be a bathroom. It does have to have walls, and it cannot just be a toilet area. So there's got to be some sink and things that are available for that employee. Then you also must designate where they can store that fresh milk that has been pumped. So there should be a policy that you have in your handbook about this. New York State also requires new hires to be signing off on this policy as well. So there's, again, a lot of nuances here. So it's important to make sure that your handbook and your new hire policies are up to date. I did have a client say to me that they did not think that the New York State sexual harassment training was still a thing. They said, well, when Cuomo was removed, didn't that end? And no, it did not end. The requirement includes new hires signing off and being trained at their during their new hire status. So they're signing off on your written policy, and then taking the training during their new hire status. And then there has to be annual training for all employees every single year. And that includes board members and contractors, right? Because anyone representing your company has the opportunity to do some damage, unfortunately, in the event that there is any sort of accusation, okay? Everybody's favorite topic here, the COVID sick leave topic. It is sunsetting on July 31st, 2025. We finally found that out. But until then, we still do need to comply with this. So if an employee does get COVID and they are calling in, COVID pay does apply. And depending on the size of your business, they either have up to 5 or 14 days and up to 3 episodes in a year. So they don't need to stay out for the 5 or 14 days, right? So fever-free and you feel better within 24 hours, you can come on back to work. I recommend that they wear a mask for a little bit. But it's important to make sure that you do get a PCR test as valid proof of the COVID sick leave. You should not be accepting home tests at all. If the employee has COVID, they should be getting a PCR test, or I think there's an antibodies test as well that has that specific documentation, including their positive test result and then their demographics at the top. So name, date of birth, where they went, things like that. Okay. And the New York State HERO Act. So this kind of came into place when COVID came about. We were required to have I call it an infectious disease policy, but it was all about COVID at the time. And while the policy is now inactive, right, because we don't have a pandemic going on, it still is a provision that is required of you as an employer for this policy to be in your handbook, to be given to new hires at the time that they're hired, and then to also have it posted. So you're going to have like 7-page policy posted next to your required postings, wherever you have those in the kitchen or throughout the organization. So even though this is inactive right now, it is still a policy that you have to maintain as far as all of the different nuances to making sure it's getting signed off on and it's posted. And then we have January 1st, 2025, paid prenatal leave. Okay. So currently we have New York State sick leave, which is paid. Okay. So either 5 or 40 hours or 100 or, oh my gosh, 40 hours or 156 hours. This particular prenatal leave is brand new. It is written on the same labor law as the New York State paid sick leave. However, it is an additional 20 hours of paid prenatal leave in any 52-week period. It is in addition to the New York State sick leave. It is for females who are pregnant and they need time to go get an exam or to see a doctor or to have testing done, things like that. So the regulations on this have not fully come out. I expect them out on New Year's Eve. In New York State experience, they wait till the very last minute, and then we all have to run and get ready for this. But what we know about this is this leave is not accrued; it's front loaded. Okay, so they get it right away. You can ask for medical certification for it. The leave can be taken in 1-hour increments. Okay. Any leave that they have in the event of termination does not need to be paid out upon termination. So a couple things to take note of here. New York State sick law or paid sick leave cannot be taken in hour increments. Okay, this one can. New York State paid sick leave can either be front loaded or accrued. This one is only front loaded. So when you think about if you're using a payroll system and you've got, employees doing employee self-service requesting PTO, and you've got buckets of time off, maybe you've got a PTO or a vacation bucket, you've got a sick time bucket, you're going to need a prenatal bucket because it's a policy on its own. It's not the same. It can't be lumped in with your other policies. So you're going to need to create a policy. And I believe New York State is going to come out with a model one, hopefully, so that we can use that. And then that's going to have to go into your handbook. And obviously, we're going to need to update payroll once more guidance has been released. And one of the things that, I'm really not sure of is, it says it's 20 hours of additional leave in any 52-week period, but it doesn't say how many times it can be used. So for instance, if I'm pregnant and I lose the baby and then I get pregnant again, do I get another allotment? Do I get more time? So there's a lot of things that are missing from this right now, and we are expecting additional information to come out. And then obviously that will be communicated. New York State Retail Worker Safety Act. New York State's going to be introducing this March 4th, 2025. It's going to become effective for entities that have 10 or more employees and are engaging in retail sales of any kind, except for the kind where you sell food on the premises and people are consuming it on your premises. So, think about a restaurant. You're going to a restaurant with your spouse. You're sitting at the restaurant. You're eating at the restaurant. That would not pertain. That particular establishment would not be part of this. Okay. But let's say you're going to Moe's Southwest Grill, right? You're going in, you're ordering food, and you're leaving. Or you're going into Target, right, to shop, or Walmart to shop. Those are the retail stores that this is going to affect. Now, again, not all of the information has been released yet. We don't know how this will impact employers that have online retail stores. But a couple things, there is going to be a model policy and training requirements that'll work very similar to the New York State sexual harassment. So they're going to need to take the training upon hire and then annually. And then for entities that have 500 or more employees, they're going to force an install of a panic button. So training policies, it's going to include things like active shooter drills, de-escalation tactics. What do I do if someone comes in and holds me at gunpoint? Should I fight back? Should I not fight back? What are the company policies as it pertains to those types of safety issues? So more will come out on that. So I think I'm almost at that 40-minute mark. I think I'm slightly under, Christine. I'm pretty impressed with myself. I don't see questions in the chat box, but I can certainly share any. So, if an employee has 122 hours of PTO, do they still receive the 20 hours of prenatal time off? Yes, they do. That is in addition to any of your other policies. And then, Christine, is there a way to have, I guess they can't ask me questions live, can they?
Well, they can put it in the chat. Can you hear me now?
Yeah, I can hear you.
Okay, I'm trying to get myself back on here.
Okay. So I have another question. How about the 4-hour COVID booster paid time off? Is that still in effect? No, that is no longer in effect. I want to say that that went out of, I think we took that out of handbooks at the beginning of this year, actually.
I actually have a question.
Yeah.
Yeah, I'm not sure why I cannot get my face back on here. I am the worst with technology. I am so sorry. You can see me? Oh,
yeah.
Okay. Oh, I can't see me. Okay, good. So going back to the pregnancy and the lactation timeout, would it be okay if we just had a documentation for everybody, whether it's obvious or not? Because there are those that are obviously pregnant, okay? And then there are those where they are pregnant and it may not be obvious, okay? Maybe due to size or stature. And it seems like I would be more comfortable just having one plan. Everybody gets the documentation and for everybody across the board. Would that be something we'd have to, what do you think about that?
I think it really depends on which policy you're talking about. And we'd have to probably kind of sit down and talk through that a little bit because, if I'm 9 months pregnant and I'm 9 months pregnant and I'm asking you for an accommodation and you're asking me to go prove that I'm pregnant, get medical certification on pregnancy, I don't know. I'm inclined to think that will violate how the regulations are written. I do see your point, though. I mean, that would make it a whole heck of a lot easier, and it wouldn't be discriminatory because you're asking the same thing of everybody.
Right.
I'm going to take that away, and I'm going to get a legal answer for you on that.
Okay.
Okay, any other questions?
Okay, I don't see any. Um, so I do want to let everybody know this lunch and learn is going to be made available after we close. It's recorded. We're going to be sending it out in our newsletter. Any member who would like it sent directly to them, we can do that too if you want this information. Kristin, what can people do if they need more direct information like I'm asking you for? What can they do, these HR managers that are on with us?
They can certainly contact us. So my contact details are at the end of the presentation, and when that comes out, they'll be able to do that, and then I can answer basic questions if it's very nuanced and there's things about your industry or things about your business that I need to know. I may not be able to answer it without some sort of additional information, but they can certainly contact me, ask me any question that they have, and either myself or one of our team members in the HR department can certainly help them.
Okay, excellent.
Okay.
So one final time, does anyone else have any questions for Kristin? And once again, we will be making this available after, so you can circulate it to other departments and other managers. And Kristin, I want to thank you. This was really great information. I love the compliance, and I really appreciate your time with us today, and that we can give this to the rest of our membership too that weren't able to join us. So
absolutely. Thank you so much for the opportunity. I appreciate it.
Yeah, you're welcome. Thank you. All right, everyone, have a great day.
You too. Bye.